Hello.
Hi, Bruce. How are you?
I'm good. So we'll start in about 2 minutes or so. Yes, I will definitely introduce you.
Okay. All two of us.
Yeah, we'll see what happens.
It's late in the afternoon.
Yeah, yeah. How you doing?
I'm doing good. I'm
Good.
doing good. I was in I taking my daughter to get her SAT done because it's canceled in California everywhere. So we had to go out of
Wow.
state for her SAT.
I'm sorry, which state did you go to?
We went to Idaho.
Oh, Idaho. Nice.
Yeah, southern Idaho.
Perfect. Yeah,
Not
strange
much.
times.
Yeah, very different than the Bay Area, that's for sure. Not too many people got the COVID memo.
Yeah.
No, no masks, indoor dining. They were having their county fair this afternoon
Oh
or this
man.
weekend.
Wow.
Yeah,
I Yeah, politically and socially, I definitely tend more towards the liberal side. But on COVID health matters, I'm about as conservative as you get. We don't leave the house, period.
yeah, yeah, yeah. It was a little unusual,
Yeah.
very unusual.
It's tough because, like, even here, we've got a 10-year-old son, and he's got friends that are doing play dates and stuff. And, my wife and I look at each other and, we want to be cautious, but we don't want to be stupid. And, there's definitely something to be said for having social interaction, especially at that age.
Sure.
You know,
Yeah,
it's tough, real
yeah.
tough.
We have a 10-year-old also, and it's been real. It's been much tougher on him than our 17-year-old.
Yeah, they're both doing online schooling, I assume.
Are my son is in private school, my daughter's in public school, and his private school will be going back in person at the end of the month.
Wow. And how do you feel about that?
I'm actually okay with it. I'm on the board of the school, so I've got a little bit of more of an insight into actual the work that's been done to get them to this place safely.
Yep.
And they're being very conservative about it. So I'm pretty comfortable with it.
Good. Good. I'm glad.
Yeah.
Yeah, yeah. The local school district in the summer sent an online survey to the parents for the whole community, wherever. That's a whole long, convoluted thing. There was only one question that mattered. It was the very last one, which is, any comments? And my comment was, Zachary, my son, I said, Zachary will not be setting foot in a school building in 2020 and possibly in 2021.
Yeah.
You can do whatever you want.
Right. Right.
We
Right.
will
Yep.
make appropriate arrangements.
And there's some parents in our school that feel that way, and the school is ready to provide both options. So they're
Yeah,
set up to provide in person as well as distance for those people who aren't comfortable returning.
yeah,
So
that makes sense. All right, why don't we give it one more minute? Uh, I'm not sure what time we scheduled to start. Maybe we're supposed to start already. All right.
4:05 we were scheduled for.
All right. Well, it's 4:07, so let's start. Hello, everybody. My name is Bruce Eisen. I'm an attorney here in LA. I focus on entertainment, media, technology, and business matters. I don't know much about COVID. I know enough to find somebody who knows a lot about COVID. So I'm going to introduce Lisa Sween and ask Lisa to tell us a bit about yourself, and then just dive right in and tell us everything we need to know about returning to work in this rather strange time we find ourselves.
Super. Thanks, Bruce, and welcome everyone. This landscape is changing not only on a weekly basis, but on a daily basis. And so some of the information that I'm going to be giving you today is more focused on best practices, regardless of what location you're in. Jackson Lewis is a firm across the country. So we've got offices across the entire country. We've got over 1,000 attorneys. And all we do as a firm is practice management side employment law. So representing companies, managers, supervisors in any and all employment related issues. So we've been spending a lot of time since March focused on COVID. And if there is more information that you need from today's topic that I don't cover, we have just a ton of COVID related resources on our website. Feel free to log on to that and peruse around. And of course, if you've got any questions about anything that I'm talking about today, I'm more than happy to talk offline. My contact information is on the first page of the slide. It's lisa.sween@jacksonlewis.com. So here is our agenda today. I'm going to try to hit every single one of these topics today. We're starting a little bit late, but I think we can still hit the highlights for every single one of these topics of returning to work. One of my favorites is responding to employees who refuse to come back to work. What do we do about continued remote work? And then how are companies handling the distance learning, back to school, and the need to attend needs when the children are not back at school? So let's just jump right in and talk about returning to work. So some general business considerations, and that's really what this is. It's a balancing between the law, the various different local, state, and federal guidance or ordinances or regulations, and really what is your needs as a business organization with respect to staffing. And so one of the first things I want to make sure this audience understands when you're talking about returning employees to work, the how, the when, the why, the where, you really need to be mindful that the most important employment tenet in any employment related decision you make, the most important one, is are you selecting people for whatever decision you're making, whether it's a layoff or a return to work, are you using neutral selection criteria? So legitimate business reasons that are completely untethered to either their protected characteristics, for example, age, race, gender, religion, or untethered to whether or not that employee has engaged in what we call protected activity. Protected activity is any type of workplace complaint that is protected under the law. So it could be something like complaining about how they're paid or when they're paid, complaining about their inability to take meal periods or rest breaks, or complaining about serious issues like hostile work environment or discrimination. Any of those types of complaints, regardless of whether they're legitimate in your eyes or not, is protected activity. And when you're selecting employees to return to work, you really need to look yourself in the mirror and say, am I making this decision completely unrelated to who the person is or what they have done? So let me give you an example. You've got a position that is needs to be filled now that you're reopening. You've got 10 people who have been laid off, and you can only select 5 to bring back into the position at this point in time. If you select 5 people and other 5 people are not selected, you need to be asking yourself, why am I not selecting the 5 I didn't select? Have any of them engaged in protected activity? Is there an adverse impact on those that I'm not selecting when we're talking about who I'm allowing to return? For example, could women or could people over the age of 40 claim that you are favoring younger people or men in returning people to work? And so you really want to make sure you're looking at a neutral selection criteria for both any layoffs as well as any return to work. And of course, other business considerations are which employees are necessary. So for example, maybe one of your selection criteria is the longevity or the seniority of the person. And I'm not talking about union related issues. I'm sure that folks on this call have union workers. There may be union bumping rights that you need to keep in mind, but primarily from a business perspective, which employees are most necessary in order to accomplish what you need to get done? And likewise, which employees can or should continue to work remotely. Remember, at least in California right now, we still have a requirement that those who can work remote should remain working remote. So when you're selecting employees to return to work, are they essential workers? Are they employees that are essential and that their work cannot be performed remotely? And if not, you should allow them to continue to work remote. And of course, there's a lot of business implications around the shoulda, woulda, coulda. Everything is a balancing interest and dependent on where you are comfortable on a risk scale. Another thing you need to keep in mind as you're returning folks to work is any changes to their pay or their hours of work. So is the position now part-time? Is the position now you need to work from 6 a.m. to 10 a.m. rather than from 8 a.m. to 3 p.m. because you need to provide a different staggered schedule for folks in order to meet the safety requirements? If any of those things are true and you've got employees who are non-exempt employees, in other words, paid hourly, who are entitled to overtime and meal and rest breaks, if you are in the state of California, you are required to provide them with notification in writing of the change to their pay and their hours worked. That is something that's called the Wage Theft Prevention Act notice. You can get it off of the Department of Labor Standards Enforcement Act or Department of Labor Standards Enforcement website, DLSE, and you'll need to provide them with notification of the difference in their pay or hours worked. You also need to make sure you're following your local county ordinances, specifically with respect to any rights of reemployment. Here in San Francisco, and I know in the city of LA and LA County, there are rights of reemployment ordinances which require employers of a certain size who laid off a certain number of employees to first rehire or return those laid off employees to the workplace before you can go hire new employees. You also want to consider, do you want to have a return to work letter that spells out any new terms and conditions of returning to work? For example, now might be a really good time to include an arbitration agreement in any return to work letters, an arbitration agreement that perhaps has a class action waiver component to it that can really reduce liability for wage and hour issues on a class-wide basis. So you should be talking with your external employment counsel if now is the time to have return to work letters, maybe roll out a new handbook, maybe roll out a new arbitration agreement, and think about ways that you can tweak the business operation to insulate the company more from potential liability. I mentioned this earlier, but you should also think about from a safety perspective, perhaps scheduling employees to come in on different days or during different hours in order to minimize exposure and satisfy either local or county safety guidelines. Those are all things that go into the business consideration of returning employees back to work. So getting employees back to work, and specifically safety protocols. The CDC's been very busy this year or this summer, as have many local and county departments with respect to very requirements. You should be sure the types of guidance you have for operation. You should make sure that you're familiar with OSHA's new guidance and safety requirements. And why is that so important? Because in our next slides, when we talk about employees' refusal to return to work, that is most likely going to be premised on a concern that the workplace is not safe, which is an OSHA-related complaint. So you want to get out ahead of that and really make sure you're updating all of your OSHA paperwork, including providing any training that may be required under OSHA. Make sure you understand what your state and local requirements are with respect to social distancing, face mask coverings, sanitization, and all of the things that we've been talking about on the news for the last several months. and make sure that you understand if the county has any posting requirements around social distancing protocols or other safety. If you do, you want to make sure that that's posted in a break room or another local area that employees can easily access and satisfy your posting requirements. So what about employee training? So under OSHA, they're meant to provide some ways, but what about just from a best practice perspective? What I'm finding a lot is that my clients are nervous about providing communication based about what is going on behind the scenes because they don't want to necessarily provide any additional anxiety with respect to the situation. And I that the more training and the more communication you can provide to your employees now about all of the measures you're continuing to take and tweaking the interest, it's going to give your employees actually more of a sense of comfort than anxiety because they know that you're on top of it and you're following the various different changing tides with respect to what's regarding training and safety. A word about personal protective equipment. This is a term, unless you really are providing. PPE is a specific type of equipment that's really used and intended to create a barrier to transmission. PPE is things like the N95 mask, maybe it's a face. What you see in hospitals, really. Most employers are not providing PPE equipment. They may be providing face coverings or some form of a mask or inviting employees to bring in their own face coverings. But be very careful in describing it as PPE because there's definitely certain requirements around training how to use PPE, how to put it on, don it, doff it, take it off, keep it clean. And you don't want to get into the business of living as PPE. Other things you might want to consider with respect to safety protocols is whether you can put any guardrails around otherwise regular business needs like business travel. Is there going to be a protocol or a practice to suspend business travel or notify you for business travel? Those are types of policies I might consider making before allowing to return to work. I could talk an hour alone about the protocols for positive testing, so I'm just going to hit this slide. The first and most important thing that you need to understand is alerts you that they have tested COVID-19. You do have a requirement to contact their local county public health department in the county in which they live, not in the county in which the business operates, but in the county in which they live, and advise the health department that this employee has notified you that they've tested positive. And at that point, the county health department has their own protocols with respect to what steps they take. Steps you should take as an employer with respect to your own contacting, and that's CONTACT, contact tracing. You want to notify employees, but you want to do so without identity of the employee at issue. The employee has medical privacy rights. To our clients is that you say something along the lines of to this work location has tested positive for COVID-19. And you can send that statement out to the location company. Again, that is a of communication, but the steps that you take after that need to be much more narrow in scope. So when you begin to talk to the employee who tested positive and engage in this contact testing or contact tracing, identify only those employees who have had close contacts or prolonged or both within the last 14 days. So close contact is anything in less than a 6 feet distance. And the word prolonged is over time. but general best practice lines of 30 minutes. A ride up in an elevator is probably not going to be sufficient to require that person to be part of the contact tree. The next thing you want to make sure you're thinking about with your human resources department is considering all of the leave entitlements that employee may have with respect to sick leave and or leave under the Family First Coronavirus Act, which we'll talk about in a second. And the workers' compensation piece here, it shocks most people if they haven't heard about it. In March, Gavin Newsom issued an executive order that said, if they subtract COVID-19, there is going to be a per se presumption, a workers' compensation event. Another, they have the ability to file a workers' compensation claim against your workers' compensation. And of course, that could be, or it could be a very expensive amount depending on how sick they get. This is a per se presumption, and the employer does have to rebut that presumption through it elsewhere. So we suggest that when someone tells you that they're positive 19, that you have a conversation. You don't directly ask them where did they contract it, because that could implicate their privacy, but listen to what they tell you when they tell you that they've tested positive. A lot of employees will say things like, I was at my Uncle Joe's 80th birthday party and we were all there and I'm pretty sure I got it from Sam. And so make sure you keep those notes because you may need them later for a workers' compensation claim. With respect to screening employees, you have employees on site at a work location that you engage in a daily health certification or health screening process. Many companies at this point have an app that they can load on phone that allows them to quickly do a health certification before they come on site. The certification is our recommendations for these certification questions is symptom-based certification. So within the last 14 days, or let's even make it simpler, recently have you had a fever within the last 14 days above 100.4? Have body aches? Do you have loss of smell? So rather than asking them to certify that haven't tested positive, which may be a medical inquiry, which we'll talk about in a second, it's much better to go down the route of a symptomatic certification. The temperature taking was sort of all the rage as employers were returning folks to work and know how to do it, and the and the wage and hour requirements. And what I can tell you right now is temperature taking of employees has fallen for a couple of reasons. One, the CDC continues to change what level of temperature is an indicator. It was 100.4 at one point. It's gone at various times. It's fluctuated from that. CDC also says that temperature alone is not necessarily an indicator, but it really should be combined with other symptoms and temperature taking. In San Francisco, for example, we are prohibited from taking the temperatures of employees, and that is a recent county order. So if you are taking temperatures, you want to make sure that the county doesn't have some new rule or regulation that prohibits that. So what are we testing? Can we require our employees to get? So under current cannot require them to get tested. It is considered a medical examination, and it must be closely tied to business need in order for it to be mandatory. And so just a general, please go get tested for COVID-19, not going to Department of Fair Employment and Housing or the Equal Opportunity Commission. Um, However, you can certainly employee that they get tested. Can you require them to give you proof of a negative test before returning to work? You cannot. You can require a doctor certifying that they are COVID, but you cannot require those to you a negative COVID test. And amongst all of these things, you really want to make and the significance of the privacy considerations that apply, because in California, there's all sorts of rules around medical privacy, and you are documents for an employee's medical, which could be a temperature. You may be inadvertently creating a medical record which has up to a 30-year shelf life, a document retention life. So be very careful how you proceed here. With respect to reimbursement, screening and testing, if you do require an employee and they don't have a thermometer, you may be required to reimburse them for that cost. If you require employees to line up to have their temperature taken, they are essentially on the clock, and all of that time that they're standing in line to get their temperature taken is compensable. If you require them to take their temperature at home, that is compensable time. Get rid of what's called the de minimis rule with respect to compensable time. So anytime that an employee is doing something at the direction of the employer, it is compensable. So what about employees refusing to return to work? Here again, employees refuse to return to work because the workplace is not safe. And so the more you can communicate to them the protocols you've put in place and the guardrails you've put in place, the less likely they can make a good faith argument for their safety. Here's a step-by-step system you can put in place. Obviously, you want to first talk with your employee and determine the reason that they are refusing to return to work. It may or may not be safety. It could be childcare issues, in which case, second. Second thing you want to do is make sure you really understand what that employee's entitlements are. Are they entitled to stay home? Are they a non-essential worker? And thus the state is saying non-essential worker. You want to make sure you understand if they are in a vulnerable population, if they are susceptible to COVID-19, right to stay home. If they have the right to stay home, what are their leave entitlements? Are they family first coronavirus requirements, which I'll get to in a second? Aren't eligible for that, are a disability, either a physical or mental disability, that would allow them to seek leave as a reasonable accommodation under the Americans with Disability Act or the Fair Employment and Housing Act in California. And if they have a disability, for example, maybe they have an anxiety disorder. Does the employee have any paid time off or sick leave or vacation that use in order to take some period of leave? Are they entitled to leave under any other state or local law? For example, is the reason that they refuse, they've got somebody at home who is very ill with coronavirus, so perhaps they have rights under the Rights Act to take leave. You really want to engage in what we call the interactive process. That's a term of art. There's a discussion with the employee. Information made that allow that employee to either return to work remote, or to take leave. And then obviously, as the catch-all, there's always the opportunity to leave of absence. And frankly, if they don't fall into any of those steps 1 through 8 and they're being insubordinate, you can always consider dismissal, but that's certainly going to be a high rate now. So what kinds of, we've got the Expanded Family and Medical Leave Act under the Family. You've got your LA and CFRA. You've got leave, got FEHA disability leave laws. now so that we can make sure we're covering the family and medical leaves under the Coronavirus Act. So the first thing you want to consider is this person qualified for leave under the FMLA, the regular FMLA? Is COVID-19 a serious health condition? The Department of Labor says that it may be if there's complications from it, but it's not leave that's provided solely to avoid exposure if they don't have some complication. And this is that they get the CFRA leave if it results in incontinue vision by a healthcare provider. In addition to requirements, which is really just what we call job, there's a second layer that you always have to consider, which is leave and accommodation under the disability laws, under the Fair Employment and Housing Act. Is a disability? For example, are there pre-existing disabilities, anxiety disorder that gets by the pandemic? And is requesting not to wear a mask a reasonable accommodation? Does somebody have some form of breathing disorder that, as a reasonable accommodation, they can't wear a mask? You're going to want to need an interactive process to.
Hey, Lisa, you can continue.
Say again?
I've got to jump off. You can continue. I say I've got to jump off to do another seminar.
Sure.
You guys can continue. Please feel free to do so. I just want to say thank you.
Super. Thanks, Bruce.
Bye.
Take care. Federal Fairness Act. This is for employers with less than 500 employees, and there's really two buckets here. The sick leave. Employees are entitled to up to 80 hours of sick leave if they've worked for the company for at least 30 days. The sick leave is paid out at a 2/3 average regular rate, and it's capped at $200 a day or $10,000 in the aggregate. With less than 5 days. In California, we also have separate state and local sick leave to consider. And I've listed here local ordinance recently implemented new sick leave laws that you should look at if you're in any of those locations. Remote work conditions, just generally you should identify are not to remote work. So maybe as a reasonable accommodation, you can allow that person to continue remotely. Always want to think about what is the length of the accommodation. And document with the employee, is this a long-term solution? Is this a transitional solution? Is this limited to the COVID-19 pandemic? You'll want to make sure that you're identifying the equipment necessary for employees to work from home and to reimburse them for all necessary and reasonable business expenses related to their remote work to the employee. The work reimbursement rule is it reasonable? So you don't have to grant every employee's request for everything that they ask for, but you do have to determine if it's necessary and reasonable. And at a minimum, most folks are saying they're providing a stipend with respect to phone and internet usage. If you don't have a phone and internet, you should definitely work with Employment Council to draft one because there are specific requirements under California law with respect to those types. Regarding childcare leave issues under the Family First Coronavirus Act, you ended FMLA entitlement. So this is just adding one more eligibility factor to the FMLA other than the need to take time off for a serious health condition. You can now also take time off because of a school closure or a child. You get 12 weeks of time under the expanded FMLA. 2 of those weeks are, but you can replace the 80 hours of sick leave for that otherwise 2 weeks of unpaid time. And the remaining 10 weeks is at 2/3 pay. So all in total, you get 2 weeks at 2/3 pay under the sick leave law and 10 weeks of 2/3 pay under the expanded FMLA. Also keep in mind, under California Labor Code Section 230.8, parents are allowed up to 40 hours per year or 8 hours per month of leave to attend to childcare or to school issues. So you can't discriminate or retaliate against an employee with respect to time off under the Labor Code Section 230.8. As I mentioned before, allows you to take those 2 weeks to care for a child whose place of care is closed or whose school is closed. This applies even if the school is operating in a distance learning model but is actually still closed. And if there's a hybrid approach, you should seek guidance from Employment Counsel because that is a changing venue every day. Accommodations you might want to consider with respect to childcare issues is, could you allow the employee to change to a part-time schedule or reduced hour schedule? Can you modify their duties at all to allow them to work remote? Can you transfer them to another position? Other business considerations you might want to take into consideration, however, is that if you're reducing these hours, from full-time to part-time, you want to make sure you don't lose their still need salary basis test in order to be classified as an exempt employee and not open yourselves up to other wage and hour issues inadvertently. That is it. Thank you so much for joining me today. If you have any questions at all, you can reach me at lisa.sween@jacksonlewis.com, and please feel free to log on to our website, a whole host of cars, resources, and employer-related charts for employment insurance and COVID-19 issues. Thank you so much for joining me today, and best of luck.